The European Union bill, known as the Repeal bill, no longer great, is a key part of the government's Brexit strategy. It will repeal the 1972 European Communities Act, which took Britain into the EU, and remove the supremacy of Brussels law. Brexit Secretary David Davis said the bill is one of the most significant pieces of legislation that has ever passed through Parliament, and has asked MPs across the House to work together to deliver it. But Labour's shadow Brexit Secretary, Keir Starmer, says in its current form, the bill gives ministers sweeping delegated powers, which would allow the government to alter legislation with minimal parliamentary scrutiny. The Labour Party says it'll vote against the legislation unless there are significant changes. The bill is not expected to be debated in the Commons or the Lords until the autumn, but it will need to be passed by the time the UK leaves the EU on the current timetable scheduled for March 2019. And I'm joined now by David Jones, who was until recently a minister in the Department for Exiting the EU. Welcome to the programme. Now, Douglas Alexander, the majority of Labour MPs voted to trigger Article 50, which started this process. But an essential part of this process is this so-called repeal bill. And they're now threatening to vote against it. How does that work?
Because they accept the principle that Britain will leave the European Union, but they're not convinced by what, by David Davis's reckoning, is one of the most important pieces of legislation to come before the Commons in many decades. They're doing their job in making sure that they scrutinise this bill effectively and make sure it's the best possible bill given the circumstances the country finds itself in.
It's not trying to frustrate the Brexit process? I mean, if they were, they may not have the numbers, but if they were to vote this bill down, what would happen?
Well, it's ultimately in the government's hands. I mean, I think the Labour Party leadership has taken quite a lot of heat in recent months for not seeking to circumvent or to deny the vote that was cast on the 23rd of June last year, at the same time as saying there are significant changes that can and should be made to this bill. For example, the Henry VIII powers, the way devolution is treated. There are very significant principles embedded in this legislation which deserve to be scrutinised by Parliament.
It makes it a lot more difficult if you're going to face guerrilla war from the Labour Party now, doesn't it, given it's a hung parliament?
It does, and I think that the point is that the Labour Party supported the notification of withdrawal bill, which of course was the legislation that led to triggering Article 50, and having done that, I think that they've got a duty to act positively towards this bill and not seek to frustrate it. I think Douglas
but they're right to, I mean, their job as the opposition, their job is to scrutinise it, and they don't need to accept everything. They may accept the principle. I heard a Labour spokesman this morning saying they do. But it's then their job, if the bits they don't like, they're perfectly entitled to vote against it.
Well, I'm not sure that Keir Starmer sounds as if he's accepting the principle at the moment. But I think moving beyond that, yes, of course we accept that the bill has got to be scrutinised. And I think that one of the most positive things recently was the House of Lords Constitution Committee report, which actually suggested a way forward in terms of scrutiny. I think that's a really good basis for going forward, having, for example, joint committees of both houses scrutinising the legislation before each clause is put forward, and I think that that's a really good basis for discussion.
The shadow Brexit minister has, quote, put the government on notice. The leader of the Liberal Democrats, still for a while, says the repeal bill will, quote, be hell. You must be glad you're not in that department anymore.
Well, there are compensations not being in the department.
This sounds like trench warfare, doesn't it?
I think that the comments of Tim Farron are really, frankly, ridiculous to suggest that the process is going to be hell. I fully accept that politicians on all sides are going to have to scrutinise this, and there'll be Conservative colleagues who want to do that too. But to talk in terms of, as he is effectively wrecking it, I think is very irresponsible.
Should Labour vote against the second reading of it? I mean, I can see why in committee or in, I don't know, it's going to be a separate committee or done on the floor of the House, that they will put lots of amendments and the things that they're entitled to vote against. But should they vote against the second reading?
I think that largely depends on what kind of commitments the ministers give in the course of the second reading debate. I think it's regrettable, frankly, the bill wasn't published in draft so that there could be pre-legislative scrutiny, because a lot of these issues could have been resolved if there was a pre-legislative draft produced. That scrutiny is now going to happen in the course of the passage in Parliament.
The government says it's ready to listen on Brexit. David Davis says MPs must work together. The Prime Minister keeps on asking the Labour Party for ideas and so on. But where has the government given concessions on this?
Well, we haven't seen the bill yet. The bill has not yet been published.
But the point is, it could have given concessions to incorporate it in the bill, and we have no indication that that's the case.
Well, as I say, so far the bill has not yet been published, but I mean, clearly the government have made it clear that they're very happy and indeed anxious to discuss the way forward with other parties. The Prime Minister couldn't have been clearer.
This issue of these so-called Henry VIII powers, which means that you can alter legislation, the government can, by a statutory instrument rather than legislation. I mean, you can see why people will be wary of that. On the other hand, we've only got to March 2019 to get all this stuff onto the British legal framework. I mean, surely there's really no other way of doing it. It's a massive bill.
But my sense is there's no difficulty in incorporating many thousands of statutory instruments onto the statute so that we've got legal certainty moving beyond March the 29th. The question is, has the government in this bill given adequate assurance that there won't be a continuing capability for very significant pieces of legislation to be amended by statutory instrument, thereby, if you like, enabling not taking back control by Parliament, but actually a loss of parliamentary scrutiny.
Because the executive would
Because
do
the
this
executive, rather than the Parliament, has that ongoing power.
What do you say to that?
Well, I think it's very clear that the bill will have a sunset clause. In other words, those powers can't be exercised indefinitely. Again, I return to the suggestions of the House of Lords Constitution Committee, which is that we should have pre-legislative scrutiny, that the power should be exercised only on certain terms.
Right, well, I'm glad you brought up for the second time the Lords report on this, because they said the repeal bill will, quote, involve massive transfer of legislative competence from Parliament to government.
It could potentially.
Well, they said it will.
And that is why the scrutiny process is so important. The suggestion by the House of Lords Committee was that there should be joint committees looking at the legislation before it came through. And they also suggested constraining the powers by applying it only to the extent necessary to correct the British statute book and also to ensure that anything that was agreed during the negotiation process could also be incorporated. And I think that the government would be willing to listen to those proposals.
The head of the National Audit Office, an impartial, highly respected civil servant, he says the government's Brexit strategy is in danger, quote, of falling apart like a chocolate orange.
Well, actually, I would have thought a chocolate orange was a particularly well-engineered confectionery item.
Yeah, but it does tend to fall. He was comparing it to a cricket bat, which is rather more sturdy than a chocolate orange.
I read what he had to say, and having been in the department, I can confirm that DEXU, the Department for Exiting the European Union, is right across Whitehall on this, and I didn't recognise...
So why would he say that?
Well, frankly, I didn't recognise the criticisms he made, because it didn't reflect anything that I was aware of when I was there.
The Labour Party, Douglas Alexander, now says it wants to incorporate the European Charter of Fundamental Rights into UK law, not the European Court based in Strasbourg, but the European Charter of Fundamental Rights. Yet this was the charter which, in power, Labour said would have no more significance than the Beano and wouldn't really involve Britain. And yet you now want to write it into UK law. Why?
My understanding is that Keir has included that as a request from the Labour Party.
He has, that's why I'm
of
raising
this.
it.
Because, first of all, it has taken on a greater significance in terms of a modern expression of both social and employment rights within Europe than may have been anticipated at the time of your initial comments. But also his policy concern is to make sure that we don't see a degradation of employment and social and human rights as a consequence of the acquis being written into the British statute.
Surely that's a matter that now for Parliament, if Parliament or under, say, this government, it was to start to erode workers' rights, then Labour would surely fight the next election saying this is an outrage, we're going to reverse that and get elected on that basis. But why do you need a European Charter once described as the
Because
Beano?
Labour MPs were elected to this Parliament on a mandate not of a great repeal bill, but a bill that would guarantee all of those human, social and employment rights.
But why do we need a European Charter to do that? Are we not capable... We already have the jurisdiction of the European Court of Human Rights based in Strasbourg, and we remain under that jurisdiction. And I think even the Conservatives have said that ain't going to change. Parliament becomes sovereign in these matters. We elect Parliament. why do we need a European charter?
For example, you've already had Philip Hammond, an increasingly influential Chancellor of the Exchequer, threatening the spectre of a kind of North Atlantic Singapore, where employment rights, for example, would be reduced as a consequence of a changed
But
economic
that would be a
model.
matter of democratic... If the country voted to go that way, fine, and in the unlikely event, I would suggest, if it doesn't, you can stop that.
But the country has voted for Labour MPs to go that way.
Why give all this power to lawyers? You don't trust politicians?
Well, ultimately, Parliament is the forum in which these matters are going to be determined, and Keir Starmer's doing his job.
Well, the Charter of Fundamental Rights is, in effect, a signposting measure, and it refers to underlying rights. Now, those underlying rights will not be affected in any way by this legislation. They will remain there. And repeatedly, ministers in this government have given assurances that there will be no degradation, no erosion of workers' rights.
OK. So you think it would be wrong to include this European Charter?
I think it's unnecessary for the reasons you've actually just given.
All right, we shall see. And we'll see whether it's a red line, or it'll be interesting on that.